But first, the federal government is tonight pouring cold water on expectations that thousands of rejected asylum seekers will have their cases reheard by the Refugee Review Tribunal. Attorney General Darryl Williams says yesterday's High Court ruling is a test case and was a technical one and may not have implications beyond the 2 asylum seekers directly involved. Despite that, refugee support groups are confident that the ruling on procedural fairness will lead to a complete overhaul of the government's refugee policy.
Say it loud, say it clear, refugees are welcome here.
Demonstrators rally outside the Refugee Review Tribunal in Sydney, welcoming a High Court ruling that they say leaves the government's refugee policy in tatters. But their message fell on deaf ears.
I think now's probably enough time, so if I could ask you to move along.
Joe, who doesn't want his identity revealed, is one of thousands of asylum seekers whose cases may have to be reconsidered. He says he's experienced firsthand the tribunal's failure to fully consider claims in accordance with the law.
Even sometimes they don't go through our papers properly. If they go through our papers and if they actually listen to what we say, I think most probably they should give us status in Australia.
Immigration lawyers have applauded the court's decision, which they regard as a victory for all asylum seekers.
This is a very strong message to the government that it should do something to correct its decision-making processes to make them fairer.
The lawyers who led the test case believe the ruling could be applied to up to 50,000 rejected applicants.
Each one of those people who are named in the proceedings should ultimately be entitled to go back to the Refugee Review Tribunal, and the tribunal would be required to rehear their case.
But the federal government says the implications are limited to the 2 Chinese Indonesians involved in the test case.
It's wrong to suggest that the whole system was criticised. It was just in these 2 cases, particular issues arose as to the way the process was followed. The High Court did not sit in judgment on the whole system.
Woomera solicitor Jeremy Moore believes at least half of the 200 detainees in Woomera can now challenge findings against them, including members of the Bakhtiari family who were rejected in July last year because they're thought to be Pakistani, not refugees from Afghanistan.
A lot of us have known for a long time that the High Court would eventually come to the rescue and say that the government had got it wrong as to its treatment of refugees. They hadn't been making decisions fairly, and the process was basically corrupt. So this is a testament to that.
If the High Court decision has the ramifications that people talk about, clearly the current system isn't working, and it's another reason why it needs an overhaul, and we need to get a lasting solution.
The Office of Immigration Minister Philip Ruddock says he's overseas and out of contact, but it concedes rehearing many thousands of cases would seriously stretch the resources of the tribunal.